SCOTUS hears Colorado Trump ballot insurrection case, conservative angle. The Supreme Court of the United States, SCOTUS, heard arguments in the case of Trump v. Anderson, regarding Donald Trump being ruled ineligible to appear on the Colorado presidential ballot because of his part in the insurrection. Arnina called that case a grotesque use of lawfare. The oral arguments today reinforced that sense of grotesque lawfare. If you are like me, you are still feeling salty that 6 voters filed suit in Colorado to bar Trump from the ballot, that the Colorado Supreme Court heard the case, and that 4 of the 7 Colorado justices ruled that Trump could be barred from the ballot as an insurrectionist. We remember that he has never been charged, tried, or found guilty of insurrection. This whole thing seems anti-republic. The good news is that oral arguments were heard in the Supreme Court today in Trump v. Anderson. You can listen to the arguments here. For much of the arguments, they could have been arguing how many angels could dance on the head of a pin. The arguments were that much in the weeds. From every corner, the television lawyers thought the Supreme Court cast a gimlet eye towards Colorado's arguments. From CBS News, Washington, the Supreme Court seemed skeptical of the idea that Colorado can exclude former President Donald Trump from the state's primary ballot, with justices on both sides of the ideological spectrum warning during oral arguments of the consequences of ruling him ineligible for the White House. The case, known as Trump versus Anderson, involves whether Trump is disqualified from holding the presidency again because of his conduct surrounding the January 6, 2021, assault on the U.S. Capitol. The dispute puts the 9 justices into new legal territory, and their opinion could have sweeping implications for the 2024 presidential race. The case hinges on Section 3 of the 14th Amendment, which bars officials who have sworn to support the Constitution from serving in government if they engage in insurrection. The provision was enacted in 1868 to prevent former Confederates from holding office, and laid mostly dormant for more than 150 years. Maybe the provision should lie dormant for another 150 years. Especially when an event has never been adjudicated an insurrection. The last hour of the SCOTUS arguments was fraught with the word insurrection. It was infuriating and anti-American to listen to that kind of gaslighting. Ketanji Brown Jackson was firm, but fair with Trump's lawyer. Why would this not be an insurrection? Justice Ketanji Brown Jackson asked lawyer Jonathan Mitchell as the 9 justices of the Supreme Court were hearing oral arguments in a landmark case over whether Trump, the GOP frontrunner, can remain on Colorado's primary ballot ahead of the 2024 election. Mitchell responded, for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. Brown shot back, and so, the point is that a chaotic effort to overthrow the government is not an insurrection? Mitchell went on to say, we didn't concede that it's an effort to overthrow the government either, and chalked up the deadly events of January 6 to a shameful and criminal day. None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but did not qualify as an insurrection as that term is used in Section 3 inches of the 14th Amendment, Mitchell said. Almost felt sorry for Jason Murray, the lawyer for Colorado. When Gorsuch says, put it aside, I am not going to say it again, put it aside, it sounded like Gorsuch was scolding an errant child. And, the protesters were out at SCOTUS because Trump is a white man. The SCOTUS will have this, hopefully, 9-0 ruling back before Super Tuesday on March 5, 2024. Featured composite. Fred Schilling, wikimediacommons.org/public domain, Quick Spice, flickr.com/cropped/Creative Commons.